Associate Counsel here at Boughton, and I'm also the Editor-in-Chief of Executive Tax Briefs. We do a national webinar, tax update monthly. We're dealing with a lot of these issues. We read a lot of stuff. Interestingly, the feds came up with this shocking new revelation on principal residences yesterday, which it really wasn't a loophole. It's just that the rules weren't being enforced. So that's going to be very interesting for a lot of people, and it isn't necessarily just foreigners. I think probably what they're really after is a whole lot of locals who just aren't reporting the principal residence exemption transactions, and particularly is true for we've got dad dies, mom's in the home, kids have to move her out. They don't want to sell the home, and then the home is out there for 5 or 6 or 7 years being rented out. It's going to be interesting to see how this all works out, but I think there's a lot of people who have been cheating the system. So interesting things, interesting days. So this is a program on family business succession. One of our major banks, CIBC, has done a number of reports on this and has indicated that over the next 5 years, they estimate $2 trillion, $1.9 trillion is going to change hands over the next 5 years. It's like double that if you extend it out over the next 15 years. So for those of you who are here and those of you online, financial professionals, this is a really big deal. And I think what we're seeing, and we got a decent sized group here, that a lot of it is not really getting dealt with. People just don't like to talk about death and dying and wills, and they just don't want to deal with it. And typically the people who make this happen are people sitting at this table, and the people on the other end of the line here are financial professionals who really need to sit down and talk to their clients to get a plan together, because without a plan, the only people who win are the lawyers. Yep. So, I want to keep this moving on time, but I just wanted to give you a bit of an overview. I want to tell you a little bit about who our group is. Well, Boughton Business Succession Team. We've a mid-sized firm, but we've got a really good team here. We can cover pretty much every area of the law. Unlike a lot of tax and estates, there are couple of tax specialty firms in town. There are a number of accounting firms who specialize in tax, but they're not very good at being lawyers. Sorry, guys. And most of them who know that will refer the work. But I just wanted to point out that we have a good group here. We've got, in terms of key employee issues, we've got Elizabeth Reed over here. Stand up and wave your hand, Elizabeth. On family law, we have Chantal Catamol and Jennifer Lynn. Thanks, Jennifer. Corporate commercial, we got a whole group of people. We got Luca, who's going to speak a little bit later. Intellectual property, we have a fellow by the name of Tony Wilson, who's presently writing the new Franchise Act of BC, which is going to cause major headaches and pretty much a guaranteed for-life job for Tony, who's drafting this new legislation. It's going to be a big deal if you're dealing with people involved in franchise businesses. So on the intellectual property side, Tony Bennett Lee here at our shop. And then on the tax and estate side, we have Jim Baird. Jim has had a major impact on the redrafting of the Wills and Estates and Succession Act. So Jim is one of the experts in the province. With Jim is Catherine Kim, who's going to be doing a presentation on the estate side. And Catherine's also joined us on the tax group now, which is terrific. I've been doing this for over 30 years. I was a CFO before I started practicing tax. I've worked in Ottawa. I have written letters for the Minister of National Revenue. I've drafted legislation for the Minister of Finance. I've worked at McCarthy's. I've done billion-dollar transactions. We've pretty much done it all. We've seen it all. I'm glad to be here in Vancouver. Love it here. I didn't like the 16-hour work days at McCarthy's in Toronto, but I learned a lot. We also have a fellow by the name of Moon Ma, who's also a CPA and a lawyer who works with us here. He's got about a dozen years of experience. He actually worked at CRA, which is quite handy at times in terms of dealing with some of the appeal work we do. And then we have our resident pit bull, Jeff Glasner, who is amazing when it comes to dealing with problems with CRA. So we've got a nice little group here, get the job done. And we've done pretty much everything. The last few years, we've done several $100 million deals, small firm, but we are able to get pretty much anything done and take great pride in bringing solutions to the table. We recently had a deal walk in the door. PwC out of Toronto was advising. I looked at it for 10 minutes and said, this isn't going to work, and you're going to cost my client $2.5 million. And they restructured the deal. We ended up running the deal because they just, apparently they didn't understand we had provincial sales tax in BC. Anyway, we like to provide solutions, so let's get going. Enough about us. Let's talk about issues related to transferring your business. So Luca, over to you. I'll just get you right here. And that's the slide.
Morning, everybody. Thank you, Bill. So as Bill said, my name is Luca Citon. I'm a shareholder here at Boughton. I've been practicing for about 15 years, and my practice is, again, Bill was saying, is transactional work, corporate commercial. So for the most part, what I do is help companies buy and sell. So hopefully what we can share with you today is something of some value. So let's get on to the first slide here. So the way we had sort of conceived of this program is splitting into 3 checklists. And what I find whenever I attend a lot of these sessions is that, I might hear a bunch of things, but there's nothing necessarily for me to take away. So we wanted to give you guys something to take away at the end of this, and you'll find in your folders for each of our 3 presentations a checklist. The notion being that once you're finished here, if you need to go back with your clients or at any time, you'll have the checklist available, things to think about, things to remind yourself. So, I mean, we all go to a lot of these things and we lose the PowerPoint or we forget what's being said. It's nice to have something to take away. I was lucky enough chosen to go first because none of you want to hear about tax at 8 a.m. I know I don't. And we figured what we would do is, because Bill's is going to be second, the tax side, I would ease you in with some nice fluffy corporate stuff. Some of you guys may know a lot of this stuff, but it's just, you're going to be eating, take it in, because with Bill's presentation, it's probably going to require your full attention. And, last thing I want to say is, because we're only about 30 here in the room, if you do have questions, raise your hand. We'll just get it dealt with as you have the question come up. There hopefully we'll have some time at the end, but on the off chance that there isn't, might as well ask away. So, getting started here. So here's just an outline of the 3 checklists. Mine there up front, the legal readiness. We're going to go, for each one there, these are the various slides and the things we're going to talk about. So we're going to talk about the business's external contracts, the relationships with external parties. We're going to talk about our employee contracts, which is why we had one of our employment lawyers here, Elizabeth, attend in case there's any questions on that front. We're going to deal with some IP issues, corporate records, which are near and dear to everybody's hearts, shareholders agreements, and then a couple sort of preliminary stage agreements, the confidentiality agreement that you're going to want signed in advance, and the letter of intent. So we're not going to get actually into the transaction documents, just because this is meant to be a prelim up to that stage. So, here, again, the point of the checklist that we wanted was, again, to give you some indications of some of the legal steps so that you can get a smooth transaction and achieve the best possible price for the sale. And in preparing for this, the metaphor I've used, and I've spoken to clients before using this, is when you go to sell your apartment, you're going to stage it. You're going to paint the walls, fix the leaky faucet, do whatever you can to make that apartment look as good as it can for sale. And the same applies to the business. There are a lot of things that can be done beyond simply showing profits and all the rest. That'll on the surface will make the business a lot more attractive to those people who are going through it, going through the transaction. And so a lot of you here know this as well, that the sale itself can be a lengthy transaction from start to finish. And we're not talking about once you engage the lawyers, but I'm talking about from beginning, where you start considering, or your clients start considering getting ready for sale. I mean, this could easily be 2 to 5 years we've seen when people first start thinking of passing the business down and then actually being ready to sign a contract. So a lot of these things that can be done, we encourage everyone to get started early. And again, partially why we're doing the presentation, because at some point, once the letter of intent is signed, presumably, or the confidentiality agreement, somebody like myself, or you guys as well, you're going to engage in some fairly extensive due diligence of that company. And we're going to look at all these things that we're going to go through today. So it's best to be prepared, to know in advance what you're dealing with and be able to advise your clients on these matters. And of course, at the very last point here, each business is going to have its own nuances. So not everything that we're going to go through will apply to every business, but we try to speak in generalizations for the sake of this presentation today. So this is, I put this slide up front because it is one of the more important ones, one of the bigger ones with the most consideration. And we're probably going to spend a few minutes here on this one. And so this is the notion of your external relationships, the business's external relationships. And what we're talking about here are contracts with suppliers, licensees, landlords, and customers. And again, a buyer and the advisors speaking to them, they're going to want to look through all these contracts and discuss these matters with the buyer. Lapsed contracts or no contracts are a big concern. If we start going through everything and we see that there's a termination provision or because the contract hasn't been renewed, it's a bit of an issue. Just as an example, right now on my desk I have a transaction where the target company is a manufacturer of foodstuffs, and we started commencing our due diligence and we started looking through. We asked for we send the other side a list of documents we want to see, and included amongst those documents was a request to see contracts with the manufacturers of the actual products and then the distributors. And what we found out was that there were no contracts. And so this target company, they had been engaging manufacturers to produce the foodstuffs and giving them recipes and all the intellectual property related to the products they were making, and there was nothing to govern that relationship. There was no confidentiality provisions, nothing to prevent that manufacturer to use that IP and give it to somebody else. Of course, we're relying on the goodwill of that end manufacturer to not do that. They're professionals, and that's what we were told. But we went back to our client on this, and all of a sudden, when those recipes, and if you're a manufacturer of these kinds of products, that intellectual property, that's a big asset. That's that's how we came to the value of the company. All of a sudden now, that value of that asset dropped. We went back and we said, listen, this is a big issue. The price is dropping. We're not paying the same price that we thought it was because the intellectual property isn't as valuable as we initially thought. So in these instances, with clients like this, what we want to see in advance and what we'll insist on is that with these external relationships, there is some kind of written contract to govern that relationship. And things like confidentiality are key. And the second to last bullet here, the assignability, and obviously a very big crucial clause. And for those of you who are used to this kind of thing, you see leases all the time in these business sales. Generally, it's not a problem if the lease is towards being terminated. We can engage a new lease or ask for an extension. But the assignability provision and change of control is always a big issue, and it can always be a big hiccup. And generally what that refers to, again, is that if there's a change in control of the tenant company, generally the landlord has to give their consent to any assignability of that contract. And if you're lucky, there is no assignability contract. If you're a little less lucky, there is an assignment provision, but all that requires is financial credibility of the new tenant. But they're getting more and more sophisticated. I had a file a couple months back, and the deal actually fell apart because of the change in control provision. And it wasn't a massive deal. It was a fairly known restaurant in town, and they were in an area of town that leases are hard to come by, and they're very valuable. And the change in control provision had the usual, it had the financial credibility, but because it was in a restaurant district, they also had this provision that I hadn't seen before that related to the reputation of the new tenant. They actually had in there, the assignment provision was 2 or 3 pages long, and they wanted letters from this person's professional community to vouch for his reputation, which was something new that I hadn't seen before. And it was a bit ridiculous, and we couldn't get them to change this and to reconsider. And you'd think it wouldn't be an issue, but once you had the financials approved, but it was, and the deal fell apart. Unfortunately, our client wasn't willing to go through all that and have that known to his community, and so the deal fell apart. So again, something that we're going to look at in advance, and it would be nice when you're speaking with your clients to know what these provisions are going to look like. And that brings us to our last point here, that it's amazing when we get into a deal, and I know there's a lot of brokers in the room, so you're probably already doing this when you get a client, but it's awesome and makes our job so much easier if when these businesses are getting ready to sell, they prepare and maintain some kind of schedule or chart or some kind of regular update stating sort of the contracts that they have, some of the key terms, termination provisions, assignability, just to keep an index of everything, even if it's just a folder, to have everything in that folder, to have everything handy, rather than us having to, as the target company lawyers, as the purchase company lawyers, having to figure out what we need. If you're able to just sort of pass it all over, it makes our job and the transaction so much easier. So that's the external side. I was going to talk a little bit about licenses, but we want to keep things moving, so maybe we'll hold that to the end. Maybe the last thing I would say is key clients. If you're in the business with customers that you have large sale orders, and it is business practice to ensure that those customers sign contracts for the continual provision of services and products, it's great to get, we always ask for a rep and warranty during the deal that, largely that supply or that purchase is not going to change as a result of new ownership. It's nice to see, again, that there's some kind of cemented contract with big clients and big customers to continue the purchasing even after any change of control. Hard to get, but ideal. Okay, employee contracts. So again, we did this in its own slide because it is a pretty big issue, and one of the key things that are going to be important when we're looking at purchasing a business are the employees. And we're not just talking about certain clauses like the non-competes and the non-solicits, but even just the key employees. And a lot of times we get these companies where there's 2 or 3 people who've been running the business, and the business can't run without them. So if we're looking to sell, usually those same guys are the owners. They may want to get out down the road. It's important to know that the guys below them, their managers, that they're locked in as well, so that when we go to transfer the business, they're happy, they're going to stick around, and because they're going to be essential to the running of that. And again, what we're going to want to see, we go through the contracts all the time. We ask for the stack of employment agreements. We're going to go through the non-solicits and the non-competes. And one of the more crucial terms is severance. We had a deal about a year ago that it was 2 Canadian companies nationwide. One was the largest in its industry, purchasing its second competitor. And the reason the deal worked from our client's perspective was that they had efficiencies in place that once they purchased the client list and all the products from their competitor, the numbers would work if they were able to let go a number of the employees because they had efficiencies in place that they didn't need to double up. So going into the deal, we knew severance was going to be an issue. And we were talking about a couple $1 million easy that deal was going to incur after closing. So thankfully, what had happened is, because we had hundreds of employees across the country, the target company, they had been planning for this deal for a while. So they actually did have a chart and everything cemented in place to list out all the key terms for all the employees. We knew how long each person had been there. We knew what their contract said. We knew that the contracts did provide for severance, so we didn't have to do a common law calculation to try and figure out if terminated, okay, they've been here this long, they make this kind of money, this is what we're going to have to pay them. So it was incredibly helpful to have that known in advance, what we were looking at on this with respect to severance. If we hadn't had that, not just our legal fees would have gone up a huge amount, but potentially if we were having to not deal with written employment agreements and have to deal with the common law severance provisions, it would have been pretty ugly. And so one of the reasons we had Elizabeth Reed here, one of our employment lawyers, join us, I had her here just in case there were any questions on the employee side. Elizabeth, was there anything that you wanted to add to this at all about things that might be thoughtful or things they should keep in mind?
Sure. I think the only thing I'd add is Luca mentioned a deal that we had where there was a nice stack of employment contracts that we could just look at. What's much more common is that we say, well, can we see your employment contracts? And they look at us and kind of go, huh? We did like a handshake 30 years ago? That's not good enough. So that is an employment contract, but unfortunately that doesn't contain the key terms of salary severance. So particularly for small businesses, you often have a lot of loyalty. You have people who are going to be with the business for a really long time. Those are the people that also have potentially huge severance obligations towards them. So that's the kind of thing that the earlier you can get it in place, the better.
Perfect. Thank you, Elizabeth. Next up, IP issue.
So would you say, like, when we first started business with severance, put 1 month per year, or how would you say that?
Exactly. The key is, ideally, you want to get the contracts in place right when people start. Often we know that isn't possible. So when you're at the point where you're looking at selling the business, there are ways to implement employment contracts at that time, if you haven't done so in the past. But you have to be very careful about how those are implemented, because if you don't do it right, then they won't be enforceable. So more challenging to do it in the middle, but certainly possible, and I would recommend it because it cleans up the business.
We're working on a file right now where the employee's been there forever, and you mentioned the 1 month per year, and you start working this out, the numbers become huge, absolutely huge. Or a situation I had, a software company, where the first 25 guys signed the contract, and then they got sloppy, and the next 25 guys are writing the software code come in. We're selling the business for $60 million, and the last 25 guys never signed the contract. And now we're trying to do a deal with a major company, and we don't own the code. So it's an important issue that carefully.
You actually stepped on my toes a bit on that one, Bill. This is my next slide here, which that was going to be my anecdote, but okay. Sorry, another question?
So most people make their employment standard severance, right? That's put up in some standard document, and anything over and above that, not even down. Well, the employment standards minimums is just the absolute bare minimum that someone can give. If you don't have a written contract that's enforceable that limits your notice, you're going to be subject to what's called common law notice, and that's basically what the judges have sort of said are the kind of key principles. So when that happens, if you're subject to common law, I have to go back, look at the case law, figure out, okay, this is how old the employee is, this is how long they've been there, and it's a much more sort of complicated process, and you're looking at potentially, like for a 30-year employee, you're looking at 2 years of notice, potentially. So if you have a contract, you can limit that. The appropriate amount is going to depend on, if it's a very junior employee, you might just offer them the standard minimum. If it's somebody much more senior, to be competitive, you probably have to offer more.
Was this not a contract thing that was applied by the employment standards contract 20 years ago? Was that enforceable?
We do recommend that people review their contracts as every couple of years at least, particularly if people are making major changes in their position. So if you signed an employment contract as, you started as a janitor and now you're the CEO, that might be, they might, the court might look at that and say, well, this has sort of clearly been superseded by the employment relationship. That's not, depending on the circumstances, that still could be enforceable. But ideally, you want to keep looking at those contracts. Perfect time to do it is when people have promotions. That's a great time to look at it and put in place a contract if you don't have any.
Yeah, exactly. So one of the keys here with not just the employee contracts, but the external contracts that we recommend is exactly what came out here, is a continual review. Every couple of years, and even sooner, if you're getting to the point where you're considering selling, it's not just a one-time do a review. This should be something that's a continually, ideally annual, if not even more so, review and ongoing consideration of all these contracts. So moving along, IP, intellectual property. So these days, intellectual property is crucial. Whether you're talking about an actual copyright, trademark, patent, or we're talking about a branding, any kind of design, these more and more, these are very important to the value of the business. And chain of title is the key. When we go to commence due diligence, we're looking to ensure that from creation to the target company, there is clear chain of title evidencing that that company owns that intellectual property. And the simplest forms, obviously, as we mentioned, if it's a trademark, the filing of that trademark; if it's a copyright, the filing of the copyright, or a patent. And again, these things, I'm a trademark agent. I can tell you a trademark's going to take from 10 to 14 months. So these aren't things that happen overnight, and they need to be thought through, and you want them done in advance. I don't want to be looking at a company and see that they just filed the trademark 2 days before we're closing. That doesn't really help me because I know I might get opposed. I know I might not get registered, and I'm not going to know that for 10 to 12 months. And one of the key issues that Bill mentioned that was going to be my big anecdote for this slide that he kind of stepped on is this fourth point here that, going back to the employment and contractor agreements, who people who provide services. We did have a software company last year that they were selling the business, and the business involved a piece of software. That was the whole business. And the business was licensing out this software to all their clients. And they had a massive database. The company did very well. They had a great offer from a U.S. company that was trying to cement their position in Canada. We did the deal, and the day or 2 days after the deal closed, all of a sudden, former contractors started coming out of the woodwork and saying, listen, we helped write that code, and we never assigned that code to the company. And ideally, what there would have been with those contractors was some kind, when they were hired to write the code, something in their contract that said any work product is assigned to the company. And it's that kind of chain of title that we're going to be looking for. We weren't aware of these contractors. We asked the client, did everything get papered? They said yes. If we're not told, we can't do anything about it. In this instance, what ended up happening was the deal went through, but basically we had to put everything on hold until the litigation was resolved. And this did go to litigation. We ended up having to go to court and pay out the contractors a few $1 million for the amount of work they did, because legitimately they had done work that they hadn't been fairly paid for, and they hadn't assigned the code. So again, intellectual property these days, whether it's just a brand or actually is the business of the company, it's crucial, and it's something to be thinking about. Whether you own it or it's a license, which is the last bullet here, a lot of times you don't have ownership of the intellectual property, and all you have is a right under a license to use it. Again, if that piece of software or whatever intellectual property you're licensing is important to the business, we're going to look through those licensing agreements and ensure that, again, going back to assignability provisions, to termination provisions, we're going to want to make sure there are indemnities and limitations of liability. We're not going to buy or advise our client to buy a company where the license to use some intellectual property is a key asset, and then we see that there's, the liability is unlimited. That's not something that's going to be great. So ideally, this falls into the bucket of contracts that we have reviewed on a whatever regular basis you can with your clients. Next up, corporate records. Again, fairly simple. Everyone's quite familiar with these. It should be, it shouldn't need to be said, but obviously if we're buying the shares or even the assets these days, we still tend to look through the corporate records of a company. For those of you who don't know, every incorporated entity is required to maintain a certain amount of records, everything from annual resolutions to the registers of the shareholders and the directors. And each year, whether it's the BC Corporate Registry or federal, there are annual filings that need to be done. So the last thing we want to do is, in preparation for closing, find out that the record book for a company that maybe goes back 20, 30 years is a mess. These things can be fixed, but it just takes a lot more work, and trying to figure out when exactly 3 shareholders back somebody transferred to somebody else their shares and at what price, it's a bit of a pain, and it can take time. So ideally, These records are up to date. We don't want to go hunting down unpapered share certificates. We don't want to go hunting down unsigned resolutions where a director didn't sign it and now he's moved out of the country, he's no longer a director. Reviewing the corporate records on an annual basis, ideally you have a law firm that is handling them, so hopefully they are up to date, is something that we don't want to deal with. And oftentimes, it's surprising. You'll get a big company that's worth a fair bit of money, and we'll ask for the corporate records, and we'll get an incorporation certificate. And they'll say, look, I'm incorporated. Well, okay, well, they did it themselves, or somebody else did it for them, and they did incorporate, but all the other documents they're required to maintain aren't there. So again, we're stuck in the position of having to recreate these things and figure out way back when who had X shares and transferred it to whomever. So one more thing to add to the list to keep in mind. Shareholders agreements. So again, something that everyone's probably quite familiar with. Worst case scenario, you have a company with 2 shareholders, 50-50, and there's no shareholders agreement. One person wants to sell and the other doesn't, and then we end up at a stalemate. The shareholders agreement is meant to prevent scenarios like that if in the instance of shareholders disagreeing about the transaction. In each of these instances, these typical clauses you would see here, they offer a way out, whether it be a shotgun, a right of first refusal, a tag-along, or a drag-along. For the sake of time, I'm not going to go through everything. I think a lot of you guys are aware of what these things are, but it's important to ensure that they're all in your agreement so that we have a number of options when it comes to selling the business so that the purchaser can anticipate how the shareholders are going to behave. If there is 1 or 2 problem shareholders, we need mechanisms to get them out if we need to in advance of the sale. And one of the things I did want to mention that we've been encountering more and more, and especially since the Family Law Act changed in BC a couple of years ago, is the consideration of marital provisions in the shareholders' agreements. And usually you see one of 2 things. You'll have a clause in the agreement that will say, at the first sign of a marital dispute, the company has the right to repurchase from the shareholder who's in the midst of the dispute their shares, because we want to have that handled in advance of any divorce and any potential claim by the non-shareholder spouse against those shares. A lot of shareholders don't like this because it effectively puts their status as a shareholder out of their control because it's subject to some kind of dispute that they may not have any control over. So the alternative to having that kind of a clause is that we ask the shareholder to get the spouse to sign some kind of waiver of interest in those shares. You can imagine how that goes over sometimes. That's not always the ideal scenario, and it's often a difficult discussion that the shareholder has to have with their spouse. But when you're the other shareholders in that business, you kind of want that protection from your other partners. And I had one instance where we had 3 shareholders, and 2 of them, we sat around the table talking about this, and they said, no problem. And the third said, well, that actually might be a problem. All of a sudden, the 2 shareholders looked at the third and started to get very concerned. Not for any reason. There was no marital discord, but they just did not want to deal with that discussion with a spouse. And it became an issue. But it's something important to have in there that we want to have that protection as a potential purchaser. We also invited today in the room Jennifer Lynn, as Bill mentioned, one of our family lawyers here, specifically to address this kind of issue. Again, if there were any questions, or if, Jennifer, did you have anything that you wanted to add on this subject at all?
Thank you, Ben. Just briefly on that point, what happens to shares on marital breakdown can be quite complicated. I won't get too much detail about it here, but right now. But in a nutshell, in most cases on marital breakdown, yes, the spouse can and will probably have claims of shares. Having the spouse sign a waiver during the relationship may help, but ultimately what is the best way to protect those shares would be to have the 2 spouses, between the 2 of them, sign what's commonly known as a prenup. In states here, it's known as a marriage agreement or cohabitation agreement. That would be the shareholder and who would set up. The 2 of them would sign an agreement between the 2 of them that would deal with what would happen to those shares upon marital breakdown. You should also ask that.
Sorry, can I just interrupt? We actually have some people who are listening online, and anyone who's not at the mic is not being heard. I'm sorry, can I get you just to come up to join Luca for just a minute?
And also, if you are asking a question, just so you guys know, they are going to have to repeat the question for the people who are listening online. So I want to apologize for interrupting, but we do have a large number of people who are listening through the internet right now. So just wanted you all to be aware, and thank you for, sorry to interrupt.
No, thank you. So just to briefly repeat what I went over, upon marital breakdown, in most cases, the spouse of a shareholder can and will have a claim to those shares. And the best way to protect those shares would be to have the two spouses between the two of them, sign a cohabitation agreement or marriage agreement, what's also commonly known as a prenup, that would deal with what would happen to those shares upon marital breakdown. The spouse can also sign a waiver, as Luca has mentioned previously. Although I would point out that if that spouse did not receive independent legal advice prior to signing that waiver, that may weaken the strength of that waiver, and also as well if they did not sign independently the marriage agreement or the cohabitation agreement, as I've mentioned. I also wanted to point out that signing that waiver may not necessarily absolve the shareholder's obligation to compensate the spouse for those shares, perhaps out of other assets. So in other words, the waiver may protect the shares from being transferred to the spouse itself, but it may not adequately protect the shareholder from having to pay out, compensate that spouse for those shares, say out of the family home or some other kind of asset that's available that's considered to be a family asset.
So hopefully that sufficiently scared everybody enough to speak to their clients on that front. So a couple more slides. We'll move pretty quickly here, just because I know we're under time constraints. The last couple things I wanted to mention were confidentiality agreements and letters of intent. Up till now, we've been talking about matters that were definitely through the due diligence, and this now we're getting a little closer to the transaction. I thought these bared mentioning because it's still partially part of the due diligence. And again, we're not going to be talking about the actual transaction, just because that would be another 5-6 hour, that would be a full day session. So very quickly here, confidentiality agreements, again, for those who aren't aware, it's crucial when you're starting your due diligence before you pass over any information to the other side that something is signed protecting the confidentiality of that whatever information is provided. Some of the key things that we're going to want to see is descriptions of the information and how long, and mechanisms in terms of the return of that information. I know a lot of people they'll rip something off the internet for a confidentiality agreement and they think they're all the same, but they're not. They're all very different, and there's a lot of things that hinge on the wording of the agreement it's very important to make sure you do this piece properly, potentially if the deal falls apart. And especially now when we're dealing with so much electronic information, standard contracts will often just say the return of that information or the destruction of it. With electronic information, it's not that easy, obviously. It rests on your hard drive. It's been sent any number of places. So the provisions relating to the return of electronic information those are some of the things that we're going to be very careful about looking at, and something to keep in mind to ensure that your confidentiality agreement is up to date. And again, this will generally precede any letter of intent, which our last slide here. And the benefit to having a letter of intent, and again, all the brokers in the room here can probably attest to it, is that it helps deal with some of the big picture and the potential deal breaker issues before it comes to counsel to deal with the actual transaction, including obviously things like purchase price, holdback provisions, employment issues, all these kinds of key issues that we want consolidated in advance of the transaction starting. It also helps to gauge interest when you start talking about a deposit. It helps to gauge interest in the potential purchaser and help build deal momentum. And so without that, oftentimes the deal can fall apart very quickly if we just get to drafting the purchase agreement and one or two clauses that nobody had considered before all of a sudden spur some kind of argument. So again, it's very beneficial on that end. Some of the things that generally the LOIs are non-binding, but some of the things that you're going to want to see that will be binding regardless, issues relating to deposit, again, to confidentiality provisions, and ideally some kind of no-shop clause, a provision preventing the potential vendor from speaking to other potential purchasers while you're still negotiating with them. You want to lock them down and ensure that at least that clause is binding. So that was the last of my slides. I'm hoping this warms you up for Bill's tax discussion, so you guys are sufficiently awake now to focus on what is going to be the most interesting tax issues you've ever heard.
Thanks, Luca.
I'll go over to the question side here to monitor the questions. Thank you, everybody.
Thank you, Luca. And sorry to those of you who are online. We'll try and manage that a little better in terms of the questions that are being asked. It's always good to get questions from people who are dealing with real files and real people. Certainly, that's the stuff that's the most important. So, a lot of businesses, probably the majority, pass from one generation to the next. It's all in the family. And there are all kinds of tax planning strategies you can use, and I'm sure many of you, because most of you are financial either planners or accountants, you've all sort of dealt with this stuff. You're familiar with the some of the planning techniques. Actually, what's surprising though is a lot of the planning techniques that people use, they really haven't really thought through to the end game, and that's one thing we find in our group. It's fine to do an estate freeze, but you got to think it all the way out to the end. What happens when mom and dad die, and what is the actual plan? In fact, does it work? And things like crystallizations of capital gains exemptions, in many cases, are just a really bad idea because people haven't thought it through. They don't understand how the rules work. So I'm going to try and give you that sort of a quick brush over the top here in terms of things you need to know about. So, you know, as we mentioned, there's a huge amount of wealth that's going to change hands here. So you got to do this in advance. You can't leave it to the last minute. Obviously, there's opportunities here with state freezes to avoid paying large amounts of capital gains tax. I mean, we have death taxes. They've hidden all the inheritance and death taxes, but it's in the Income Tax Act, deemed dispositions on death. Family trusts, which many people are familiar with, which were used extensively for basically income splitting reasons, now with this generation are very useful in terms of pushing off the shift of the growth in value to the next generation to avoid the tax. Very important strategy. Capital gains exemption, of course, is a big deal. It's now about $824,000 per individual, which is not chump change when you work out the capital gains rate at 24 points. So what we want to do is provide you, and we have provided you with a couple of checklists. A lot of the family trusts are disaster areas. And the only good news here is that CRA is absolutely useless in sort of auditing trusts. They have not done a good job. There's 2 centers in the country. They're totally disorganized, but I fear that they are getting themselves organized. I think the trust returns are all going to be computerized, and it's going to be a nightmare because I'd say probably 60–70% of what we see is badly done. There's no proper annual maintenance, and so we've got an extensive checklist in our materials. Have a look at it. If you're an accountant, you should be looking at this every year. Honest to goodness, if you've got, you know, unless you've got a trust that was just being used for income splitting and the kids are all minors and you're not using it anymore, but other than that, you should be looking at it because once a year, we see a trust come in this office where they've missed the 21-year deemed disposition and they're sitting on shares that are millions of dollars in value. So there's a lot of things here that can be done if you keep track of what's going on. So basic rules, if you got clients who are 50 plus, you should be talking to them. You should definitely be talking to them. I know for a lot of accountants, they don't really want to raise the subject because they're so darn busy, and these issues tend to come up around T1 time. I mean, as soon as you get into January, you're just busy, busy, busy. But you really should be making a note of these people. If you can't deal with it in tax season, May, June, July, you should come back, you should sit down. The clients are going to appreciate it. So don't wait till they're past age 65. That's the magic age range. This should be basically something that's in your system that you're looking at every year. If you don't deal with it, you're going to lose the clients because the kids are going to be really angry when they find out the mess you've left them. Okay, what do you need to get started? Here's a list of things. It amazes me. I'm not encouraging accountants to practice law, but you should have a copy of your client's will, for heaven's sake. A lot of clients don't even have a will. If you don't have a will, you're not organized. And I mean, if you've got a client even with a small business can be worth, you know, 7 figures easily, $1 million here or there. If you don't have a will, it can be a mess. And again, the only people who win on this are the litigation lawyers when they come to deal with the stuff. So get a copy of the will, family trust, get the Form C-99 history from CRA, get the list of assets. Things that are really a big problem are wealthy clients inevitably will have one member of the family who's moved south of the border and didn't come back. And that is a huge problem. It's, you know, I would say once a month I run into a situation where one of the kids went to Stanford or something and never came back, and they married, and now they're sitting in a family trust and they're a U.S. person. You know, it's a difficult issue, but sticking your head in the sand is not doing your clients any favors. So get the information. Preferably get an organizational structure if it's complicated at all. You need to sort of look at the stuff and get out in front of it. So what are we trying to do here? We're trying to make sure that we don't leave a huge tax problem and a big mess, or if there's nobody in the family that's going to take over the business, you're going to be talking to Luca, and you need some kind of viable exit strategy, which means you really need to look at the company. You need to figure out whether they own the IP. It's all of those things, basically doing due diligence on a company, a family-owned company, to get it ready for sale. Things that you need to worry about, I mean, I've seen it all. I've had 3 deals in the last 3 years where there were 7 kids in the family, and they tried to transition the businesses to the next family, the next generation. Very interesting, the things that happen. We do use shareholder agreements within a family group to try and deal with this. So, you know, you need to have a discussion. Otherwise, you transfer a business and you've got 7 kids, or even if you've got 3 kids, even if you've got 2 kids. It's amazing the problems you can encounter if you don't have the discussions in advance. And basically, it's the financial professionals who are in a position to deal with it. If you're not doing it, the clients aren't doing it, and then what you end up with is a big mess. So possibly you want to look at shareholders agreements even in a family-controlled situation. Who is the logical successor? Oftentimes that isn't really sorted out. And the other thing is, oh, dad's rich, we're all going to get a piece of the pie, and now you've got the siblings fighting over what's there, and it can be a real mess to deal with. So just some basic questions to ask yourself. And it's amazing often enough, you meet the nicest people in this business. I mean, the fun part about what we do is not trying to keep up with the tax changes that are hitting you every second day. It's meeting the people and trying to figure out how to make things work for a family. But, you know, if there's more than one kid in the family, inevitably there's all kinds of different opinions. And it's not even the family that's the problem. I had 7 kids, really lovely couple. Dad spent his whole life building up, he had a portfolio of warehouses. They were paying out a very nice return every year. We sat down, we said, okay, we're going to do a trust, we're going to do a freeze, and by the way, I want a shareholders agreement because we need agreement here because there's 7 of you. 2 of the kids got it. They understood what Dad was up to. Dad wanted to keep the assets. We sat down, we thought we had an agreement, they went away, they talked to their spouses, the outlaws as I call them. In 2 weeks they came back and we had no agreement. And it took 1.5 years. Finally, the client comes back to see me here. He's given me hell because the deal I told him was going to cost $5 to $10 grand is now $45 grand and counting. And I said to him, what did I tell you? I said, you're going to have to make the decision here. And you can't leave it to your kids to decide it because every time they go away, they talk to their spouses and they all know better than you. You're the guy who created all of this. you make the decision. He finally made the decision. We signed the agreement, and every one of those kids is drawing a check for $1,000 a month. Thank you very much. Except for the fact that when mom and dad finally passed away 5 years later, I got a call. One of the sons says, I can't deal with them. They're driving me crazy. So, this is the sort of stuff you deal with families. So having a discussion with your clients about this stuff, have you provided for your spouse? Who are the heirs potentially? I had a situation where a fellow had transferred 25% of his corporate shares to his son who was a heroin addict. So he had to go up and find him in Prince George to get him to sign off on the shares. Those sorts of things can be a real big problem. Catherine's going to talk about wills and multiple wills, which can be a very good planning technique. You just really need to sort of sit down with your clients and walk through this. Considering a split of your operating company. So you've got a business that potentially could be split between, a son and a daughter or two sons. If you leave it until they're dead and mom and dad are gone, it is a huge tax problem. If you split up the business while mom and dad are still alive and they can control both businesses, you can avoid Section 55. It's a big tax problem you need to deal with while they're still alive. Do not leave this until mom and dad are dead and gone. And the other thing we've seen in some cases is where we had a situation where the son is running the business, it's a trucking business over in the island, but they have significant investment assets. Daughter's not involved. Dad wants to be fair to both of them, so we spun off the investment assets into a separate company. Son's got the operating business, daughter's got the investment business. Everybody gets a piece, but it's got to be done while mom and dad are still alive. So these are things you can really help the clients with. And again, I think most of you know these principles. By doing a freeze, you can fix today's value. And nobody really talks about this. This is not something you'll find in a tax textbook. The bottom line is, if you do a freeze and you pick the value today, chances are you're never going to have to deal with CRA, at least CRA's valuation group. So I can tell you this for a fact. When we're dealing with common shares that end up in an estate, it gets referred to their valuation group here in Vancouver, and they're a bunch of barracudas. We had a file where they assigned a value of $600,000. Not a big deal, but basically the shares were worthless. It took us over a year to convince CRA to value the business at $70,000. I kid you not. We went through that fight. I've been doing this for over 30 years, I have done freezes and freezes and more freezes. We've done freezes. I had a client that came into me, an accountant. He said, one of my clients, two clients, they're in the 70s. One of them's got a prostate scare. I think he's got cancer. We've done no planning. The business is worth $30 million. I said, don't ever mention that number to me again. Go back, look at the business. Because there's two partners. So one realistic way to value that business would be to say, well, the only way to cash in your shares, sell off all the assets, pay the taxes, distribute the money, pay the dividend taxes. What do you got left? He came back with a valuation of $12.5 million. They're on the island. Victoria CRA's got nothing else to do. They came up and they looked at the file, and the auditor, who's got no valuation experience, looked at it and said, tick. We had 12 pages of Excel spreadsheets. We had all the assumptions. We had everything laid out. We had the alternative calculations, and they've accepted it. I've had a number of deals looked at. So this is not something that's a tax planning thing per se, but doing a freeze, you pick the value. Chances are, from what I've seen, the auditors will not question the redemption amount on those freeze shares. That's a fact. So, you're looking at a $30 million deal that gets valued at 12.5 and it gets looked at, and that's not the only deal I've had. So it's very important to convince your clients to, if they're not going to sell the business, freeze it, fix the value. You pick the value. If you don't do it and they're common shares, there's a valuation group here that's got nothing else to do with CRA, and they will figure out a really nice number that works for them. Obviously, another key element here is the capital gains exemption, which, you know, at $824,000 per individual, and a 24% hit is a significant amount of money to save. I would say not most, but certainly, well, probably 50% of the times businesses get referred here, they're offside. They're not entitled to the exemption. Successful businesses typically, if they haven't done any planning, they're not entitled to the exemption because they're outside the rules. So the other important thing to talk about here is family trusts are invaluable. You can put your principal in charge. They can be the one that holds the common voting shares so they can maintain control. Every beneficiary would be entitled to their own capital gains exemption if you sell the shares. You got 21 years to wait and see before there's a deemed disposition in the trust. If the trust is set up properly, you can roll the assets out of the trust tax-free. So basically, it allows you a wait-and-see situation. And things happen in families where, you know, it doesn't work out. So maybe you don't want to distribute to one of the kids. Maybe it's just not going to work to distribute the shares. So estate freezes are incredibly valuable. And here's an example of what it should look like now. There's new rules that were introduced. For those of you who are accountants, you'll be familiar with them, but they have totally muddied the waters with the changes to Section 55. Section 55 turns an tax-free intercorporate dividend into a deemed capital gain. It used to be in a structure like this, you wouldn't necessarily have a family trust. You might do a freeze of the operating company. So we've got a cash investment here of $200,000, which is not qualifying. So again, it's only active business assets that qualify for the small business corporation test for the qualified shares. And for clients who didn't want to be involved with a family trust, they'd freeze the operating company and they'd issue nominal dividend sprinkling shares to the holding company. Under the current rules, based on what we know from CRA and what they've stated about the new purpose tests, there's one practitioner in Toronto who says, oh, it's not a big problem, it's not a big problem. These nominal dividend shares, you can just pay the extra cash out to the holding company. The shares are only worth $100. No problem, no problem. We have a national tax group that I belong to with some of the best practitioners in the country through Meritus. I've talked to our guys, and none of them will do that deal. So basically, if you're trying to keep an operating company on side, so small business deduction, clients have paid the bills, they've got enough money to live on, they're at a point in life where they're not hiring any more employees. The whole idea with the low rate of taxation is hire more employees, create more jobs, buy more inventory, buy more assets. That's why you get the break on the rate. Most mature businesses, once the clients are in their 50s, the businesses stop growing, the cash accumulates, it gets put in GICs, and then the company is offside the capital gains exemption. The shares no longer qualify. So, as I say, a simple technique would have been to do a freeze and issue nominal dividend sprinkling shares to the holding company. That no longer works. Certainly, our national group feels that. Most people I've talked to are concerned with these new rules. So the solution is you do the freeze, you issue the common shares to a family trust, and you make your holding company, which is going to be offside, a beneficiary of the trust, as you can see in the example here. So that is now the sort of the standard way where the company that's generating excess cash that's not going to be used, this is the structure you want to use. We have a sort of a fixed fee we work with in terms of charging. I sometimes get a lot of grief from counsel. Well, that's, you know, like, you guys have got standard precedent. Why is it so much? The reason it's so much is because there's all of these other rules you've got to think about, such as associating with other companies. Setting up a trust is a very dangerous thing to do if you don't know what you're doing. Our trust precedent is probably 30 pages long. Catherine and I were going through it the other day with Moon. Like literally every line in that trust indenture is there for a reason. If you are not familiar with taxes and trusts, you shouldn't be mucking about with them. There's just so many things you can do wrong, and we do see it all the time. So that's sort of the current structure for trust. That's what it should look like if you're going to do a freeze.
Yeah.
Yeah.
Are there any, I don't know if it's fairly new, are there any cases right now or fighting it or?
Nothing. There's no cases that I'm aware of. Basically, the only thing that's come out are pronouncements from CRA. And what they have said is that, so if you don't have safe income and you distribute a dividend, then you could be looking at a capital gain. So, which is great if you're going to distribute the money all the way out to an individual, because capital gains in the individual's hands are 24 points. Dividends are either 31 or 41. So some people have said, hey, great, walk me into a capital gain. I'll just add that into my CDA account. I'll distribute it. But if you don't want to distribute the money out. So now we're basically relying on CRA's pronouncements. I write a monthly newsletter. We've kind of summarized all the technical announcements. And there's June, there was a batch at the National Tax Conference. There's another group. And, you know, we try and monitor it, but there's no case law right now. So really nobody knows for sure. And what we're hoping is that CRA, I mean, we're hoping that this particularly where you have these dividend sprinkling shares that are worth $1 a share or something, they're held by the holding company. It's very simple. You don't have to go through the elaboration of a trust. But basically CRA has said safe income does not attribute to sprinkling shares. So that's what we're dealing with. Essentially, the CRA rulings is the Supreme Court of Canada when it comes to these new kind of rules. So we're stuck with that, and we'll keep monitoring it. It would be nice if they would sort of clear the air here, but you know, as I say, there's one practitioner in Ottawa or in Toronto who said, oh, you know, you're not offending the purpose rules, but if you're wrong, nobody wants to be in that place. So at $824,000 a pop per individual, the exemption is something you really want to have. It was originally introduced in the mid-'80s to encourage people to, you know, basically jobs are created in small business. That's what it's all about. So Ottawa created this exemption. I don't think it's going anywhere. I saw a situation recently, I'm going to come back to this, but there's a way to get the exemption, and there's a way not to do it. But the key thing to remember, and this is something, for those of you who are accountants, who are dealing with clients on a regular basis, for heaven's sakes, get the financial statements and look at them. 50%, if you go over the 50% mark of non-active business assets, based on fair market value, within a 24-month period, then you got to start another 24-month period. You just don't want to be there. And then if there's going to be a sale, you need to have 90% of your assets, more than 90%, to be active business assets. So you should be monitoring this on a regular basis. Don't leave it. And if you see that the client is going to be offside, and I'd say most mature businesses are going to be offside. They're successful, and people stop spending the money. They got the low tax rate. They put it in the GICs, and in a heartbeat, they're offside. I'd say 1 out of 2 that we see come into our office don't qualify for the exemption. And the clients have already counted the money. They think they're getting it. So, the technique to keep it pure is essentially this strategy here, where you do the freeze, you issue the common shares. So every year you take the excess cash, you pay it up to the family trust, you file the proper designations and elections, and the dividend literally flows through the trust and into the holding company tax-free. So that is the structure you should be using now to keep companies pure, and to not raise this with a client. And you know, I've had situations. I had a guy come in here. He was selling his A&W franchise somewhere between Prince George and Prince Rupert. Apparently, it was the ideal location. $2 million for a restaurant in the middle of nowhere. And he'd done a freeze. He'd done a crystallization, and basically all the shares of the company were owned by a holding company. Only individuals can get the capital gains exemption. This is like unbelievably bad. Now, we got lucky because he had a ton of safe income, and we took kind of an aggressive stance, and we did it, and that was like 5 years ago, and haven't heard. But I just want to say to you, I want to warn you that you should be looking, if you're doing financial stuff with a client and they have a company.
For 60% rule, what does the CRA typically look at? Will they just look at year-end, or will they ask for your monthly?
Yeah, the question is, what will CRA look at in terms of the 50%? And, you know, if you get right into it, you know, it seldom happens that they get that far into it. But I would think if they actually are doing a full audit, then they're going to be looking at monthly statements. So now, so now you've got a problem. So you go offside at one point in the last 24 months. And this is why I say, I mean, you really should, you know, if you've got clients who've got a successful business and they're no longer, they don't need the extra money. I mean, they don't need to take it out. They're only paying, you know, 13% tax. So why would they do anything with it? They're going to put the money into investment assets. If they don't have a separate company, if they don't have the structure that I had in slide 19, they're going to be offside. You know, you guys, you financial professionals have got to catch this stuff and deal with it, because once you're offside, the 50% test, and it happens all the time. We see it all the time. Once you're off, in theory, I mean, even if it's just for a day or a month or 1 month end, 1 month end financial statement, then you're starting a new 24-month clock. So it's a big problem. Crystallizing, I mean, there's been a lot of this. In the early 90s, everybody thought they were going to take the exemption away. So then there was a lot of crystallizing going on. So crystallizing is simply triggering a gain while the company's shares are qualified. So because most lawyers didn't know how to do an internal crystallization, we'll set you up a holding company. We'll transfer shares of OpCo to the holding company, and we'll trigger the capital gains. So now you've got the capital gains exemption, and you've got the basis on the shares. And the obvious problem with that, I kid you not, I had somebody in my office just this last month, and the accountant was recommending, well, they might take this away. Well, I don't know what they're thinking because it's now indexed, but they might take it away. Just transfer your shares into your holding company. I said to the client, I said, okay, and when you sell the shares, you can never sell an investment holding company. They don't sell. Nobody wants to buy investments. You get a big tax bill, you're not going to do it. So when you sell the shares of your operating company with your 122 employees and a really successful business, where's the money going? In the holding company. And then how are you going to get it? Yeah, well, I'm going to pay 31 or 41 points of tax. Yeah, so that is a really bad idea. So don't do that. We've seen a lot of that. And for those of you who've had clients who did crystallizations in the early 90s with a holding company, for heaven's sakes, find them and fix it. It can be fixed. But basically, they're not going to be very happy when they go to sell their business and find out all the money is inside a company and the exemption is basically worthless. So just a warning. The other thing I want to warn you about is sometimes there is no point in taking the capital gains exemption. I can't emphasize this enough. If there is no opportunity to really sell the business, and basically what's going to happen is they're going to run it down to the end, and then they're just going to, dad dies, and it's going to go into the estate, and they're going to wind it up. If you've crystallized the capital gains exemption in the share, you've jacked their tax rate from 24 points to either 31 or 41 points of tax. So sometimes taking the capital gains exemption is a very, very bad idea. You need to understand how Section 84.1 works, and if you don't understand these rules, don't fiddle around with it, because clients are going to be very unhappy to find out you've just tacked on a significant 17-point tax bill because you didn't really understand what you're doing. So here's the chart. So this was very common in the 90s, which is the middle section. For those of you online, the right way to do this is to roll the common shares into the company in what is called an internal crystallization. You elect under Section 85 so that the basis, the capital gains exemption basis, is sitting in the shares that you personally hold. If you've got a situation like the one in the middle, it can be fixed. You can't fix it 2 days before you sell, or 2 weeks. Normally, you know, if you're trying to sell to an arm's length party, that would be a Section 55 problem. So if you've got the middle situation, you need to fix it now. So last slide. Just a reminder, and obviously, you know, high level. We're going to be around here after the session here. So if you've got situations you want to talk to us about, please come up and have a chat. And those of you online, send in your questions. We'll be happy to answer them. You know, we see a lot of this stuff that just, you kind of shake your head. It comes in. It's like, wow, I can't believe that this was allowed to get to this point. Trusts that have missed 21 years. And people have walked themselves into 84.1. They just don't understand it. So if you can understand sort of the broad brush stuff, and just give us a call. And, you know, we're happy to take a phone call, 10, 15 minutes. If we can point you in the right direction, far better to do that than just leave it. So big thing with the family trust is obviously, if you can freeze the value, you can put common shares into a trust. You can then have the growth in value go to the next generation, and you can wait and see. And we've had situations where literally it wasn't going to work out with the kids, and we've rolled the common shares after 15 years back out to mom and dad. So if it's done right, you keep all your options open. Obviously, if you've got multiple beneficiaries, you've got multiple capital gains exemptions, which is a good thing. If you've got a business that's worth a lot of money. One of the beauties of a trust is that the common shares in the trust are not subject to wills variation challenges. Inter vivos trusts are private documents as opposed to an estate where you got to file it in BC Supreme Court, and all that information is out there in the public domain. They don't form part of the deceased estate, so there's no probate or probate fees. As I say, no wills variation, and basically, just in managing unreasonable demands of family members. I mean, one of the big issues we have, and our family law lawyers will tell you, is that nobody fully understands what the new Family Law Act means with respect to beneficiaries of trust. The great Donovan Waters will tell you that a value of an interest in a discretionary trust, a fully discretionary trust, is worth 0. Our Family Law Act suggests that maybe that interest is worth something. Guys like David Thompson, who writes a lot on this at Thorson's, have suggested that a court faced with a decision on whether or not this section in the Family Law Act means something, some court is probably going to give it some meaning. So every time you set up a family trust, you need to be thinking about the family law issues related to that. So that's my little watch out spiel, and Catherine, over to you.
Okay, good morning. Can everyone hear me okay in the back there? Okay. So my name is Catherine Kim, and I'm an associate in the tax group here. I've been about law since 2011, and I have a background in corporate and estates work to supplement my tax practice. And so I'll be walking you through the estate planning portion of the agenda. So we're going to start with the benefits of preparing an estate plan, because it does take initiative to go out and talk to someone about what to do with your estate. We're also going to go over the basic components of an estate plan, and then we're getting to more advanced options like alter ego trusts and joint partner trusts. We'll also discuss briefly multiple wills, which are fairly new to BC, and we'll also do a brief refresher on the new graduated rate estate trust rules that came into effect earlier this year. And lastly, we'll provide you with a quick checklist on where to even get started with your estate plan. And just in following suit with Luca and Bill, if you do have questions along the way, feel free to raise your hand, and I will take questions. So first, why take the initiative to prepare an estate plan? The first big incentive is that you can make decisions now so your loved ones don't have to after you've gone. So maybe not all of us want to necessarily make things easier for our loved ones, but most people certainly don't want to make things harder. So by even preparing a will to appoint a personal representative, or setting out a scheme for the distribution of your assets, that in itself goes a long way in just making things a lot easier for your loved ones, just so there's not awkward decision making that's left to them after you pass. If you're a control freak like me, you also want to take control to the best that you can over what happens to your estate after you pass away. So by sitting back and considering how you want your estate assets to be distributed, you can ensure that you've got documents in place that give yourself the best chance at making sure your assets go to the people that you intend them to go to. It also reduces the risk of litigation. So most of you may have heard of will variation claims in BC. So under the former Will Variation Act and what's now the Wills, Estates and Succession Act, a spouse or a deceased, or a spouse or a child of a deceased person, and that includes biological children and formerly adopted children. So they can make a claim against your estate if they feel like they've been unfairly taken care of in a will. And that actually even happens in scenarios where there's equal division between children in a will, because sometimes you'll have a child that feels that they deserve a little more than some of their siblings, because they may have done more of the caregiving work and that sort of thing. But that's certainly legislation to be aware of in DC, and there's certain things you can do, like putting assets into a trust or preparing a will variation memorandum to supplement your will that reduces the likelihood of litigation against your estate. Because at the end of the day, if there is litigation, the winners are the estate lawyers who get to fight over your estate with opposing counsel and dwindle away your estate's assets. Lastly, a will is used to implement tax structures as part of your estate plan. So a common one is setting up distributions to your spouse or creating a spousal trust. And so with the estate plan in place, you're ensuring that your estate is distributed to your beneficiaries in a tax-efficient way, and also that they get those assets as swiftly and smoothly as possible. Is that okay?
Yeah, you're saying they can't hear you
Oh,
well.
okay. Can they hear me okay now?
Yeah.
Okay, great. Okay. When I do these presentations, I always like to, just for my own curiosity, get a show of hands on who actually has a will in place. So who here does have a will in place? Okay, all right, so that's, so we've got a pretty responsible crowd this morning, and I'm basically just preaching to the choir. But these are, words of advice you can carry on to your clients. So the components of an estate plan, as you'll see here, a will is just one of several items to consider, even though it generally tends to be the heart of your estate plan. So what a lot of people don't realize is that your will doesn't necessarily cover all of the assets that you have. The will actually often governs only a portion of your assets. So the two big exceptions are registered accounts where you can designate a beneficiary. So for example, RSPs or TFSA accounts, you can go and designate a beneficiary, and that way those assets can pass outside of your estate without having probate fees paid on them. And then they also wouldn't be subject to will variation claims. With insurance policies, you can appoint beneficiaries that way, and it's the same effect. You take those insurance policy proceeds outside of your estate. Assets that are jointly owned, so assets that are held with a co-owner in a joint tenancy arrangement or with tenants in common. So those assets in a joint tenancy scenario pass to the last surviving owner, and tenancies in common pass in accordance with the different proportions of, if you have two individuals, you've got each owner holding 50-50, and your 50% would fall into your estate and be distributed the way you specify in your estate.
I was just going to say, Catherine, joint tenancies are probably one of the least properly understood. People go to the banks and people say, "I'll just put it in joint names." It's a disaster, basically, because people don't understand. Is it the beneficial interest, or is it the title? What interests are you creating? And you know, if you talk to Jim Baird, he's written the whole pile of legislation here, he said, you know, you see many situations where people really don't have a clue. You know, you put a joint name on a piece of property that isn't principal residence, and there's a transfer of the beneficial ownership, you just disposed of half of the property. People don't really think this through. And then, of course, then there's always the family law implications that come roaring down the pipe. So you've got to be very careful when you're playing around with joint tenancies. But I see a lot of stuff coming out of banks. Well, I'll just put their name on as joint tenants, and then they can deal with it. You really need to think through, what are you doing? Are you transferring a beneficial ownership, or are you just putting their name in the title? Significantly different consequences, and you really need proper documents. It's an area that's not well understood, where there's a lot of problems. And we see court cases every month where this has not been properly dealt with.
Thanks for that, Bill. And so when you take you know, jointly held assets and assets where you can designate beneficiaries out of the equation, essentially what's covered in your will is property that's held solely in your name, where you haven't appointed a designated beneficiary. So estate plans, you know, generally do focus on, you know, what happens to your assets after you pass away, but an important part of your estate plan is you know, what happens to your assets and who makes the decisions in the event you become incapable. And so that's where power of attorney and representation agreement comes into effect. So my role in all of this is I'll meet with clients to get a sense of what their family dynamics are like, what their personal situation is like, and from that point on, I get a sense of their goals, and I walk them through different options they have on how to achieve those goals. And if there are, you know, potential risks of litigation or, you know, tax liability issues as well, it's my job to raise those and to present potential solutions to those as well.
Going back to what you said before, Bill, regards to
yeah.
Most common thing is say principal resident parent is, you know,
Yes. There's an incapacity.
There's an incapacity. They want to put the kid's name or write the kid's name in there. So the best thing we need to do is basically to document that it's a legal status transfer rather than like document something.
That is key. I mean, I had a situation where mom was having problems. The son says, "Oh, just put me on title." So they put him on title. He failed to disclose to his mother they owed CRA $800,000. Next thing you know, he's got a lien on the house. So now we're trying to establish, well, what was the intention? Was it just a matter of convenience to deal with the house and its, you know, the maintenance, or was there really an intention to transfer beneficial ownership? And like I say, there are literally, you know, if you read my newsletter, there's like a case almost every month where this wasn't clearly set out. So you really need to, like, you need to have documents to say, is this a beneficial transfer, or are you just holding the title as a bare trustee? So it's very, very important. And obviously, I mean, if it's a stock portfolio and it's gone up in value, there's a taxable disposition if it's a beneficial transfer. Now, there's some interesting case law in this area. I won't get into it, but it's a confused area of law, and I'd say most of the people who are giving advice sort of at the front line level just really don't understand the consequences. So the worst case I saw was where the son went on and there's no documents, and so CRA is assuming they own half the house. So it's a big thing to be worried about.
Next, we're getting into wills and what goes into your will. And as I mentioned before, the will does tend to be the anchor or the heart of your estate plan. So arguably, the biggest single decision you're going to make is who to appoint as your personal representative. They're also known as your executor and your trustee. That's one and the same person. It tends to be one and the same person. And so this person will effectively step into your shoes after you pass away and administer your estate. They'll handle the management of your estate and deal with all of your beneficiaries. And they've got a broad range of authorities where you're going to try and get into where your head was at when you did your estate plan and give effect to your wishes. Another item that isn't shown on the slide is that if you have minor children, a will is where you appoint a guardian in the event that both you and the other parent of your child are no longer around, and the child or the children are under 19 years of age. So I've had a number of my friends get married over the last few years, and marriage itself, for me it's an obvious trigger to get your will done, but a lot of people won't get their wills done until they have children, and they can put faces to individuals that may be impacted by your estate plan, and so at that point they'll give consideration to who they want taking care of their kids if something happens to both them and the parents of the child. And of course, the will sets out your distribution plan for your assets. So for example, if you take a couple that's married or a common law couple, a common distribution plan is to have everything roll over to your spouse or to have it rolled into a spousal trust. And if you're the last surviving spouse, then most commonly you'll have the assets divided equally between all of your children. And that takes us into tax planning strategies in place. So the transfer to the spouse and transfer into a spousal trust with the tax deferral is a common tool as well. And so other considerations, this is where we get into the validity of a will. And a lot of people actually don't realize that there are a lot of nitpicky rules under the Wills, Estates, and Succession Act. We call that WESA, and I'll be referring to that statute throughout. So there are a lot of nitpicky rules in that statute where if a will doesn't formally comply with the requirements in the statute, it can be invalid or unenforceable.
Actually, it's kind of amusing because we just had a situation this past week where there's a company involved, and there's 4 siblings, they're all adults, and one of them is running the business. And obviously he was concerned about what would happen if mom and dad were both in bad health, if they passed. So they just got out the pen, and at the bottom of the will, they just they wrote in another provision. The only problem is they were trying to deal with the assets that were inside the company. Now, not only was it not a proper coded bill, it wasn't properly executed, but they were dealing with assets that the individuals didn't actually own. Fortunately, they came to us and we're going to fix it all up, and Catherine looked at the wills and said, well, this isn't going to work, and who knows what this is, but hopefully it hasn't damaged the wills. We're going to fix it anyway, but this is the kind of stuff that people do, and you've been doing this long enough, you've seen it.
Yeah, and you do see a lot of that. So a lot of people adding handwritten notes to existing wills, thinking that that's a surefire way of getting what they want achieved, but there's obviously pitfalls with doing that. And so the validity portion is where a lot of these, do-it-yourself and fill-in-the-blank wills that you can get online. So validity is where you often run into trouble. So when I meet with a client to discuss their estate plan, one of the first things I'll do is I'll ask them to bring in their existing will. And a lot of times, especially, for example, with young entrepreneurs that I work with, these wills were done back when, they had student loans, they just come out of school, they didn't want to spend a lot of money on their estate plan. And so they've printed, a fill-in-the-blank form off the internet, and, they've presented that as their will. And I'll notice that, they'll have a witness on there that's a beneficiary under their will or a spouse of the beneficiary. And what they don't realize is that something like that, can invalidate your will. So I'll walk clients through not only what to put in their will, but, how it has to be executed, and also how to maintain it in order to make sure it stays valid for when it has to come to effect. Even little things like, unstapling an original will, it seems completely harmless, but that in itself can invalidate your will. So another consideration is updates. So, having your will done once in your lifetime and storing it in a safe deposit box, that doesn't necessarily mean that you're good for life. Life obviously is unpredictable. The only thing guaranteed in life is change. And so when there's things like a birth in the family or a death, commonly deaths of someone you've appointed as an executor or a guardian, those are, obvious triggers for updating your will. And there's other, less obvious triggers, like I had a client come in the last couple of months who was a woman whose favorite son was getting married, and she wasn't a big fan of the woman that he was about to marry. And she wanted provisions in that will that made it as airtight as possible to make sure that she couldn't get her paws, so to speak, on any of her money. And so there were trusts set in place in the will that set out distributions to grandchildren in case her favorite son didn't make it. And so there was extra wording that we could put in there to say that we didn't want the evil daughter-in-law, so to speak, to influence the children on how they were to spend their money, and that the trustee was not to take anything that the daughter-in-law said into account in making distributions to the grandchildren.
I don't know, Catherine, I think, you know, basically wills should be looked at sort of every 3 to 5 years. I mean, we had one that just came in the office we're working on right now. Both the executors are dead. So basically, the will is invalid. I mean, you know, this happens. I mean, things you can't imagine. And, you know, basically the only people who can really deal with this is we don't come and talk to your lawyer. Like, sort of, you'll do a will, and then they're out the door and they're gone. So it's really the financial people, it's the accountants, financial planners. They're the people who have the regular interface with the client. Get a copy of the will. If it's more than 5 years old, you should be sitting down and talking to your clients. Do them a favor. I mean, you know, people don't necessarily like to talk about that stuff. But, you know, when you point out, oh, by the way, your two executives are dead and your will really has no, it's not valid, and yeah, you've got several $1 million, and who knows where this is going to end up. You know, they will appreciate it.
And you know, I mean, a lot of people, if they can avoid it, you know, don't necessarily want to talk to a lawyer about anything. And so, you know, one of the reasons why we have you here today is to act as, you know, kind of the gatekeepers, and to, you know, just know that clients trust you to raise issues with them. And so, if you know, life changes or things like that happening in your clients' lives, then, you know, you can bring to their attention that they might want to have their estate plan updated.
And if you've got situations with clients that you know, and you get their authorization, send a copy of the will. It doesn't take long to read a will. I mean, if you're concerned and you're concerned about the validity, you know, it takes us 5 or 10 minutes to read through it. Okay, this is the way it works, or this is what we see. I mean, it's worth doing it. You know, clients don't want to act on it, that's fine, that's their choice. But to leave it and then find out it's a big problem, and then you've got a bunch of kids who are really unhappy with the mess that they're in, you know, you haven't really done anybody any favors.
Right. So now we get into powers of attorney and representation agreements. Before we get too much further into this, there's not a lot of estate planning movies out there, let alone sexy estate planning movies. But if you've seen Leonardo DiCaprio's movie Inception, you might recall that he is an expert in going through people's minds and, you know, going through different dimensions of reality. And there's, you know, guns and intricate plans. And really, it's just a Hollywoodized story of a son that's trying to get his dad to sign off on a power of attorney. So it's a scenario that, you know, is more relevant than you think. And a lot of people think that, you know, powers of attorney and representation agreements are for old people or people that ride motorcycles, you know, people that are really at a risk of becoming incapacitated. But, you know, they come into effect more than you think, and they're an easy enough document to have done as part of your whole estate planning package. So it's something that we always, you know, remind clients of when they do come in to meet with us. So a lot of people don't really know what the distinction is between these two agreements, and you know, the distinction depends on whatever province you happen to live in. In some provinces, a power of attorney covers, you know, healthcare decisions as well as business and financial decisions. But in BC, we've got this clear demarcation between powers of attorney and representation agreements. So a power of attorney grants someone the authority to deal with your assets, your financial assets and your business assets. And it's you know, it's an important authority you're granted to someone, so you're going to want to appoint someone that you trust. So with most couples, it tends to be the spouse. And I always recommend also appointing an alternate attorney as well. So if you've got a spouse and you've also got, for example, children that have grown and come of age, children that are at least, you know, in their mid-20s or so, or even closer to the 30s, you'll want to appoint a child of yours as your alternate attorney. You also have control over when a power of attorney comes into effect and how long it stays in effect for. So, for example, you can specify that you want the power of attorney to come into effect right away upon both you and the attorney signing it, or you can say that it only comes into effect if you become declared mentally incapable by a physician. In terms of how long you want it to be in effect for, an enduring power of attorney basically endures even if something was to happen to you and you were in a coma and lost capacity. So in the event that you're not able to make those decisions, an enduring power of attorney allows your attorney to make decisions on your behalf. There are other people that don't want their attorney to have that right. So as soon as a physician declared you incapable, you can also specify that a power of attorney is no longer valid at that point. And you also have decision making in terms of how general and broad it is versus how limited it is. So it can be as limited as having, say, your daughter, be able to access and make deposits into a specific bank account. It can be as broad as allowing your spouse or your adult child to get in and do, grant loans or transfer assets into a trust or deal with real estate property. It really can be as broad as you'd like it to be. You just have to make sure, of course, that you're granting the authority to someone that you really trust and someone that has a good sense of what kind of decisions you want to make and what your goals are. And with representation agreements, so I mentioned briefly that it essentially is a power of attorney over health and care-related decisions. And so these agreements are pursuant to BC's Representation Agreements Act, and you also have the option of making it very limited or making it very broad. Our recommended form is a broader form, so you can appoint a representative to do everything from, seeking input on the diet that you want, in case you're not able to make decisions on, what you want to eat, and you're not capable. If basically the statute sets out a list of different powers that you're granting a representative. So everything from where to live, who to live with, any special caregiving instructions, all these things that you want to be able to control at a point where you're just not able to verbalize these requests. A representation agreement is also handy if you have firm beliefs on the kind of treatments that you want in case something terrible happens. So for example, if you are dead set on not having artificial or heroic measures used on you, if you go to a hospital, it's difficult to say that a person wants that unless you've got a written document that evidences that that's what the person's clear intention. So I find that a lot of people that are really motivated to do these representation agreements are people that have firm beliefs on not having those measures used on them. So we've covered the basic components. Now we're getting more into advanced options that you and your clients can consider. So alter ego trusts and joint partner trusts are used more and more. And unfortunately, you're not eligible for these trusts until you become 65. So an alter ego trust is where you just have one individual that's settling the trust and intends to benefit from the trust. A joint partner trust is where you've got a couple and both halves of that couple do have to be at least 65. So I'll be using those terms interchangeably. So you notice that not only do they have to be 65 or older, but they also have to be resident in Canada. So what are the benefits? So a big benefit is that you are able to transfer your property into a trust on a tax-free rollover basis, and there's no deemed disposition until, in the case of an alter ego trust, you pass away, and in the case of a joint partner trust, on the last of you and your partner to pass away. Now the key to this is that by putting your assets into a trust, you're effectively removing those assets from your estate. And so the assets that you put in the trust would no longer be governed by your will. So there's a couple of major benefits to that. The first benefit that Bill touched on earlier is that those assets are no longer subject to a probate application or probate fees. Just a brief 101 on what probate is. Probate is a process that's required for most wills and most assets for the transfer of these assets. So what this is whoever is appointed as your executor under your will take the will that they're appointed under and they'll submit it to the BC court to get the official seal of approval from the court and their confirmation that this in fact is the official and up-to-date will of the deceased person. And so with that approval, the court is also confirming the executor's appointment as the legitimate personal representative of the deceased. What you'll want to know about the process is that as part of the probate application, you do have to submit a statement of assets and liabilities. And what that document is a bird's eye view of what that person had in their estate when they passed away, including the values of those assets, and it also includes liabilities. So they take the net value of your estate, and at this point, probate fees are roughly about 1.4% of the net value, so that can add up quite a bit if you've got real estate in your estate, or if you've got valuable private company shares. So we're going to come back to that, but that's an important thing to keep in mind. Not only that, but I mentioned that you've got to disclose the values of these assets, and for owners of private company shares, it's often a lot of work trying to get a valuation on your shares. And not only that, but you don't necessarily want that information to be available to the public. And so what to keep in mind with probate application documents is that if you file them into court, they're available to the public and they're essentially a public record that anyone can access. So privacy and confidentiality and respect of that in itself is a big motivator for a lot of people to use trusts, or as I'll describe later, to use multiple wills. Hey, Lynn.
The tax liability that flows from all three is the liability to the state. What do you think that for the tax liability that flows from all three trusts?
So the question was, if you use an alter ego estate and there's tax liabilities arising in the estate, then how are the liabilities handled if there's not enough funds in the alter ego trust?
That's sort of managing the beneficiaries interest.
Right. So you're managing. So how do you manage the beneficiaries' interest? So I think I'm thinking of a scenario where you've got a set of defined beneficiaries in the alter ego trust versus, say, different beneficiaries in a will. So typically, any outstanding liabilities of an alter ego trust are dealt with in the deceased estate. So for that reason, if clients do have concerns about big liabilities, they will, for example, have life insurance proceeds that are payable out to the estate. But it can get pretty tricky when you've got different people your alter ego trust versus your estate, because the people benefiting from your estate get shortchanged because they get saddled with the liabilities. So, but life insurance is certainly a really good tool. So it's just extra cash that comes into the estate that, in most cases deals with all of the liabilities. Is there anything you want to add to that, Bill? Or?
Just thinking, one of the problems, of course, is alter ego joint partner, all of the income of the assets is attributed to the settling partner or individual. So they're the ones who have to pay the tax bill. So that ends up in the estate. And yes, you can end up with a problem as to, is there, a classic example is all the money is sitting in a RIF or something, and which has got a designated beneficiary, and the money is not in the estate to pay the bill. Now you got to watch out because there's a bunch of sections. There's a recent case on this that we covered, I think, last month's newsletter, where CRA just said, well, it's too hard. We're not going to go after the estate. There's a section 160 is sort of the fraudulent conveyance. So there's a section that also allows them to go after the beneficiary. So forget that. We're just going to go after the beneficiary. Forget about the estate. We can get the money over here way easier. And of course, the beneficiary is saying, well, wait a second, you should go after the estate. I gave some money to my brother, and you should have paid the bill. So you got to watch out because there are these joint liabilities in the Income Tax Act itself. Again, very important when you're doing this tax planning. If you're doing estate planning, you have to understand where the liabilities are going to fall and be careful about the joint interest.
Thanks for that, Bill. So just briefly touching on some of the other benefits. So you know, along with taking your assets out of your estate, as Bill touched on earlier, with those assets being outside of your estate, that means they're no longer within the scope of a will variation claim. So that means that, you know, if you want to make distributions to your beneficiaries in proportions that, you know, are unequal between everyone, or that, you know, might be controversial amongst your family members. So doing that through an alter ego trust certainly does reduce, you know, the risk of any litigation against your estate. People have all sorts of reasons for, you know, providing more for one child over another, or maybe they'll want to leave more to a spouse, or, you know, a spouse number 2 or 3, compared to some of their adult children that may or may not already have, you know, funds to live off of. So that is certainly an added benefit for clients that have, you know, genuine concerns about their estates being fought over after they die. And so greater flexibility with distributions, so we discussed that, maintaining privacy and confidentiality in respect of the probate process, creditor proofing. So this is one that you're going to want to be careful with. Essentially, if you move estates out of your name into the trust, you technically aren't the beneficial owner of those assets, and so you know, that creates a barrier for creditors to get to those assets. And also, if you are a trustee of your own alter ego or joint partner trust, which in often cases you are, you maintain control of the assets during your lifetime. And an added potential benefit can be that there's no deemed disposition until death. So with inter vivos trusts, like family trusts, they're subject to that 21-year deemed disposition rule. But with these trusts, there is no deemed disposition until you die or the last of you and your spouse die. And so if you live beyond the 21 years after establishing a trust, then it's a delayed deemed disposition.
The other big issue is if you have voting shares, power of attorney cannot exercise voting rights in a private company. So oftentimes the only solution is to get a alter ego trust settled or joint partner trust settled where you can appoint. So if somebody loses capacity, you now have a trustee who can hold those shares and vote them.
With transferring, say, a principal residence and alter ego trust,
it can work, but I haven't read through the new rules, which apparently they have significantly fiddled with the rules relating to trust and principal residence exemption. Haven't had a chance to read them, but as of yesterday, I think it's a whole different. In fact, a lot of the principal residence trusts we've set up probably no longer work. So something to look at, but good question.
So the question was, you know, does putting a principal residence into an alter ego trust or a joint partner trust affect the principal residence exemption? There actually is a whole other feature called a principal residence trust, which we didn't cover in the slides, but we're happy to discuss that afterwards.
You just submit filings with respect to the principal trust exemption, or is that the part that's been debated?
I haven't looked through the rules completely, but they have announced that they have changed the eligibility. We have set up a principal residence trust where, you know, a client wants to know where the house is, you know, the house worth millions of dollars, they want to know where it's going to end up, so they put it into a trust. Sometimes we put them into alter ego or joint partner trust. You've got to be very, very careful who the beneficiaries are, because you only get one per, you know, sort of family. So you have to be, the rules are very, very tricky, and now, from what I understand, on a quick read of what they did yesterday, it's going to be much tougher to have a principal residence in a trust.
For situations like this that we have, where you have several clients that have their principal residence, and then they're buying and selling principal residence within the trust, and
Yep.
then they just submit their filings to do that.
Yep.
Is there going to be a further issue with that?
I think
the whole concept.
I think the whole concept, whether or not it qualifies at all now, and I haven't had a chance to really digest it, but yes, certainly people have put trust, principal residence in a trust, they sell it, they buy another one. If you've done it right, it still qualifies, but now I think it's going to be much harder to qualify. So
you don't recommend it now?
you know what? I got to look at the rules. You know, it's a really good idea for clients in certain situations. Got a client who's got a house that's worth millions of dollars, and his second wife, she has no kids. She's got nieces and nephews. He wants the house to eventually go to the benefit of his family. Trust works great. Now the question is whether or not it'll work. So I just don't know. Sorry, no.
Oh, that's okay. So in the interest of time, I'm just going to up to speed on this and just kind of cover the highlights. So we talked about the requirements to qualify. So you do have to be, again, 65 years of age at least, resident in Canada, and there are restrictions on those that can benefit during your lifetime. So essentially, you, in the case of an alter ego trust, or you and your spouse, in the case of a joint partner trust, are the only people that can benefit from the income of the trust during your lifetime, or the lifetime of the last surviving spouse. And you're the only one that can benefit out of both the income and the capital of the trust during your lifetime. So that's a big restriction to keep in mind. Our pitch with these types of trusts is that a properly implemented alter ego trust or joint partner trust can actually act as a substitute for both a will and a power of attorney. I mean, that's not to say that you don't need a will if you do have these trusts in place, but a will basically, as you recall, appoints your personal representative, which is key, and will take care of any sort of straggler assets that you have that haven't been settled into the trust or contributed to the trust. So other considerations, just briefly, you want to be, aware of fraudulent conveyances. So if you do have creditors at the time where you do transfer assets into your trust, there's obviously risks of that I would walk you through if that was the case. Section 75(2) is the reversionary rule. So these trusts are unique in that, you've got one individual as both a settlor and a trustee and a beneficiary of the trust. So you're essentially walking yourself into these reversionary rules, the impact of which is that any income of the trust or capital gain or loss in the trust gets attributed to you in your lifetime. Now, because trusts are taxed at the highest rate, this only really is a problem if, let's say, it generally isn't a problem basically because the trusts are taxed at the highest rate anyways. But back when Alberta had its more advantageous tax rates for its trusts, you had a lot of people setting up trusts in Alberta that would not have wanted income being attributed to them in their lifetime. And of course, there's a risk of premature taxation. So I mentioned that with these trusts, deemed disposition is on your death, not the 21-year deemed disposition rule. But if you die sooner than the 21 years, then unfortunately that means that you experience the deemed disposition sooner than the 21 years. I'm touching briefly on multiple wills. So we tend to use multiple wills in limited situations where you've got a client that has valuable assets that can be transferred without probate. So the classic example of this is valuable private company shares, or someone had a vintage Maserati or some really valuable asset that would otherwise require probate. And multiple wills tend to be for clients that haven't reached 65, so you can kind of see these as sort of a bridge or temporary solution until that client does reach 65, and at that point they become eligible to use alter ego or joint partner trusts, which in my view are a lot better. Multiple wills are also used by clients that have foreign assets. So now we've got a lot of Canadian tax residents, or Canadian residents rather, that live in different jurisdictions during the year, and they've got assets abroad. So oftentimes there's a will that governs Canadian assets, and there's a separate will that covers foreign assets. And the driving force between these multiple wills is, again, back to probate. So, people don't want to pay the 1 on their very valuable assets, and they don't want to disclose, valuations or ownership details about those assets. So by using a multiple will, you essentially take any assets that do not require probate to be transferred and plug them into your non-probate will, and any other assets that do require probate to be transferred, things like real estate or vehicles, stay within your probatable will, so to speak. And it's also key here that you appoint different executors under each of these wills. So you'll have this in the slides that you'll take home with you. The advantage is, of course, reduced probate fees and avoiding the disclosure of information that's a part of the probate process. Wills, in terms of cost, tend to be less to set up compared to trusts. And unlike trusts, there's no ongoing administration, so you don't have the annual trust tax returns to deal with or the annual trustee resolutions that have to be signed off on. There's no tax consequences that arise on the implementation of a multiple will. And there's also advantages to having one executor for, maybe lower valued assets and basic things like bank accounts versus a different executor for things like private company shares. In terms of disadvantages, so I mentioned that multiple wills are fairly new to BC. It's just under that new Wills, Estates and Succession Act that came into effect in 2014 that the Act kind of formally endorsed the multiple will strategy. Maybe not endorsed, but enabled it to be an option in BC. But our big caveat is that these wills haven't been judicially considered yet, and there hasn't been a court ruling on these yet. So there are risks related to that. Some people think they're too complicated. For example, you have to be very careful in drafting these wills to make sure you don't accidentally revoke some other will that exists out there. Sometimes describing the assets that you foresee requiring probate versus not requiring probate, or covering all of the future company shares that you might own, that does require intricate wording as well. It's laced with risk if you don't get that wording right. There's also Section 155 of WESA, under which when you get a probate grant, a clock starts ticking on the amount of time that an executor has to wait before they can distribute anything to beneficiaries. And so that time is where a spouse or a child can challenge an estate. The problem with a non-probated multiple will is that clock never starts ticking. And so you can't distribute assets to your beneficiaries unless you get the consent of every beneficiary under a will, including contingent beneficiaries, and also anyone that would have been entitled to a chunk of the estate if there was no will. So that's next of kin, and that can be quite broad, and that can be quite onerous and impractical. So if you do go ahead with the distributions without those consents, there's a chance that you can be on the hook for that as an executor. And if at the end of the day someone starts an estate litigation claim against your private company shares, well, that means that all this planning that you've done is gone to waste, because as soon as your estate gets sucked into a litigation claim, you've got to probate that will anyway, just so the executor gets that formal recognition from the court as the authority and the representative of that estate. And there can be increased estate administration costs with multiple estates, or multiple wills rather. And just briefly touching on graduated estates, graduated rate estates. So effective earlier this year, as many of you know, all testamentary trusts are subject to tax at top federal or provincial and territorial rates, other than a certain kind of estate, and that's graduated rate estates, as well as qualified disability trusts. So what you're looking at here is sort of the baseline criteria for a graduated rate estate. The next slide that's included in your materials is what qualifies as a qualified disability trust. Now, in order to ensure that CRA treats the estate as a graduated estate, the estate has to designate itself as a graduated estate, and that has to happen in the first taxation year of the estate. So designating an estate as a GRE avoids the top tax bracket for the first 36 months after a person's died. Now, why that's important is that with these changed rules, there's now certain benefits that are only accessible to graduated rate estates. So, for example, charitable gifts that are given under a will or under a beneficiary designation. So, in order to get donation tax credits for those gifts, you do have to qualify as a graduated rate estate. And for owners of private company shares, when you have a death of a shareholder and there's a redemption of shares as part of their estate plan, there's double taxation that is otherwise minimized by a particular section in the Act, 164 sub 6, in case anyone's taken notes. And so now the only estates that are eligible to use that capital gain loss carryback section is a graduated rate estate. So if you've got clients that have private company shares that plan on redeeming those shares as part of their estate plan, you want to make sure that their estate is going to qualify as graduated rate estate. And the last slide, I won't go into this in detail because you've got it in the materials. The first step, you really just want to step back, take a bird's eye view of what inventory of assets and liabilities you have, review ownership structures of assets. So, with caution, you may put certain assets in joint tenancy or joint ownership. You're going to want to sit down with your family members to, gauge their expectations on what they're going to get out of your estate after you pass away. That way, there's no surprises, and the fewer surprises, the fewer the risks of litigation. And of course, you want to set your objectives. So how do you want your assets divvied up after you pass away? who's going to take on the special role of being your personal representative, and also, you know, who would have the authority in case you weren't able to make your decisions in your lifetime. So that wraps it up, subject to any questions.